Hi, welcome to Mondays with Melissa. Today I want to talk about second marriages, blended families, and how your estate plan works into it. One of the things we see often when there is divorce and second marriage is that people forget to change their estate planning documents. So you want to make sure if you're getting remarried or just getting divorced that you would change your estate planning documents, your power of attorney, your healthcare proxy, your living will, your wills. The agents that you name can change over the years, but certainly if you are getting divorced. The other concern that you need to pay attention to is other people's relationships. So if you're leaving assets to a child who's married and has children, you might be concerned that if you leave everything to that child and then they get divorced, what's going to happen to the assets that you left to them? And in many cases, if those assets are commingled with their spouse and something happens to your child, the assets may very well be passed through their estate to their spouse. So a lot of people voice concern about that. So if something happens to my child after I die and they've inherited my assets, the assets are then going to go to their spouse, who could turn around and get remarried. And perhaps they're going to turn around and get remarried to somebody who has children from a prior marriage of their own. And now, where are those assets going? So one of the things that we really try to drive home is that you don't have to leave assets outright to that child. You can leave assets in a trust for that child, and those assets can remain in that trust, and they're available to that child for their lifetime, for whatever they want to use it for. But at their death, whatever's left in that trust goes then to continuing trust for their children or your grandchildren. So that avoids the problem of having to worry about assets passing to a spouse, again, who could potentially then remarry and your assets be passed along to other individuals who you had no intention of leaving the assets to. So not only is the issue of divorce and second marriage something you need to pay attention to, obviously for yourself if you're in that situation, but also for your beneficiaries. Another piece of this puzzle is if you are leaving assets to your child and you're saying that if your child predeceases you, their share goes to their child in trust, then you have to determine who the trustee of that trust is going to be. And one of the big questions is, do I make that trustee the other parent of my grandchild, so my daughter-in-law or my son-in-law, or do I make the trustee one of my other children, which would be their aunt or their uncle? Now that money that's in trust with a trustee is to be used for the grandchild for their lifetime, or until the age that you've dictated they would get the money outright. A lot of people like to keep it within the family and name one of their other children to be the trustee for a grandchild. Once in a while, people will choose to have it be the other parent. In a lot of cases, people are more comfortable keeping that trustee within that family unit versus choosing the other parent of the grandchild. So there's a lot that goes into this. There's a lot that goes into this conversation, and there's a lot to think about. So it's important when you come in to sit down with one of our attorneys here or myself that we have these discussions and really figure out who the appropriate people are and really what these relationships look like. Please feel free to put any questions into the comments or reach out for a consultation, and we'll see you next week.